Hello there, this is Clifford from Clifford Odhiambo Company Advocates. We are located at Jumia Place along Lenana Road in Hurlingham. Before signing a contract, one is expected to read it from up and down, from its right to its left, especially right now with the increased inclusion of arbitration clauses in many commercial agreements. But can one person wiggle out of a contract with an arbitration clause? Well, recently, one entity tried in a case that has ramifications to both investors and investment companies. This week, we look at a recent ruling of the High Court in the case of Njuguna versus Saiton High Hill Solutions LLP in administration. This case may be cited as Nairobi Milimani High Court Commercial and Tax Division Miscellaneous Civil Application Number E89 of 2022. The ruling was delivered by Honorable Justice Chepkwony on 31st of May 2022, and the ruling attempts to answer a fundamental question: under what circumstances would an arbitration clause reign supreme over an order placing a company under statutory management? This case will interest persons who have invested their funds with investment schemes that have been placed under statutory administration. The facts of the case are that on the 5th of February 2022, the court had granted Ms. Njuguna orders that permitted her to commence and continue with arbitration proceedings against the real estate investment scheme. Subsequently thereafter, Ms. Njuguna invited the Chartered Institute of Arbitrators of Kenya to appoint an arbitrator to preside over the dispute. Dissatisfied with these orders, the real estate investment scheme filed an application raising several issues, one of them being that the orders were issued ex parte, meaning that they were not heard at the first instance the matter was mentioned. This, it complained, it was against the rules of natural justice. Some of the objections raised by the real estate investment scheme were that it had more than 3,500 other investors, and the orders granted by the court had the effect of triggering an avalanche of similar applications being filed in court, and thereby undermining the objectives of administration, as the administrator's attention will be likely now shifted to defending those claims. Lastly, the real estate investment scheme argued that there were similar other applications that were filed earlier but still pending in court. The real estate investment scheme application was supported by an affidavit that was sworn by the administrator, who not only confirmed that the company had been placed under administration, but also argued that the administration orders had the effect of stalling every other legal proceeding against the company. It was further argued that the administration orders ideally meant that neither Ms. Njuguna nor any other creditor could commence and maintain any legal proceedings against the real estate investment scheme or its properties, as this would be contrary to the objectives of administration. Under Section 522 of the Insolvency Act, the objectives of placing a company under administration is to keep it as a going concern, to rescue it for the benefit of all creditors instead of liquidating it, and thirdly, and more importantly, is to realize all its properties so as to make a distribution to its preferential and secured creditors. In denying all the allegations raised by the real estate investment scheme, Ms. Njuguna complained that she had invested all her life savings with the real estate investment scheme, which had in turn failed to pay her investment on the maturity date. She argued that her dispute with the company had commenced way long before it had been placed under administration, and in any event, the company had agreed to the appointment of an arbitrator to preside over the dispute. Honorable Chepkwony, in delivering the ruling of the court, held that under the Insolvency Act, a person can commence legal proceedings against a company notwithstanding that it has been placed under administration, so long as they seek the consent of the administrator or the approval of the court. The court was satisfied that Ms. Njuguna had sought this approval from the administrator, but the approval was withheld without any reasons being given. The court defended its orders permitting Ms. Njuguna to commence arbitral proceedings against the real estate investment scheme by characterizing them as being discretionary. Section 560A of the Insolvency Act guides the court's discretion as to whether or not to permit a person to commence legal proceedings against a company that has been placed under administration. That provision of the law requires the court to consider, among many other issues, one, the impact of the orders on the applicant, especially if the applicant is likely to suffer loss, and also the purpose of placing a company under administration. The court considered Ms. Njuguna's evidence that she was an elderly retiree who had invested with the real estate investment scheme and had intended to use her investment for upkeep in retirement. Considering that the real estate investment scheme had failed to pay her investment upon maturity, the court found this was a case that was ripe for it to exercise its discretion at the ex parte stage. The court considered and was persuaded by Ms. Njuguna's evidence that she was an elderly retiree who had invested in the real estate investment scheme and had intended to use an investment for her upkeep in retirement. Considering that the company had failed to pay her investment on the maturity date, she had found herself now in a position where she was struggling to sustain herself. The court therefore found this to be a case which was ripe for it to exercise its discretion and grant the complaint orders at the ex parte stage. Lastly, the court found that the real estate investment scheme had agreed to the appointment of an arbitrator to preside over its dispute with Ms. Njuguna, and therefore could not afford to say that the orders allowing the matter be resolved through arbitration contravened its right to be heard. This case highlights the supremacy of arbitration clauses in contracts, in the sense that once parties agree to the inclusion of an arbitration clause, they are in essence agreeing to exclude all courts from presiding over any dispute that they may have regarding the enforcement of their contractual rights and obligations. It is also worth important pointing out that arbitration clauses are deemed to be independent of all the other terms of a contract, in the sense that if the principal terms of a contract are found to be void, an arbitration clause will still be deemed to be independent. Equally important to note is that an arbitration clause is expected to have all the elements that will make a contract valid. One of these elements is that the parties to the contract must have the ability and the capacity to contract. In the present case, despite one of the parties to the investment agreement being placed under administration, the presence of an administration clause meant it will stand alone despite the other parts of the contract being deemed to be frustrated by the existence of the administration orders. At Clifford Odhiambo Company Advocates, we offer attentive legal representation to individuals and entities that find themselves in disputes arising out of investment agreements that have arbitration clauses. Ours is to walk you through the process of seeking the administrator's approval to commence such arbitral proceedings, and where such approval is declined without any justifiable reasons, we'll move the court and seek for such approvals as the law requires. Well, that's it for now. Hope to see you again next time.